Fox 5 News special report.
And good afternoon, I'm Russ Spencer. We have breaking news in the Ross Harris trial. The jury in Brunswick has reached its verdict, and we expect that verdict will be read very soon in court. Ross Harris on trial for the 2014 hot car death of his son Cooper, of course. Cooper was 22 months old when he died in the back of his father's SUV on a hot June day more than 2.5 years ago now. Since the death, Ross Harris has maintained that it was a tragic accident. There you see him live in the courtroom right now. Prosecutors have painted a far different story. They accused Harris of leaving his little boy in that hot car to die so he could live a child-free life. Worth pointing out that during her testimony, his ex-wife, Leanna Harris, said, hey, she had offered him a divorce, and he said that was the last thing that he wanted. Prosecutors say Harris spent the day sexting several women while his son was dying. They say he sexted underage girls. That's part of what's going to be considered today. Let's listen to the courtroom now. That's fine.
Please be seated.
Members of the jury, it's good to see you again. My understanding is that the jury has arrived at a verdict. Would the foreperson please stand? Mr. M., is that correct? Have you in fact arrived at a verdict?
Yes, yes.
If you will hand it to the bailiff will bring the verdict to me for my review. The verdict is in proper form to be received by the court. At this time, I'm going to ask the clerk to publish the verdict. Thank you, Mr. Phillips.
In the Superior Court of Cobb County, State of Georgia versus Justin Ross Harris, defendant, case number 14-9-3124, verdict form. We, the jury, find as follows: count 1, malice murder. As to count 1, we find the defendant guilty. This 14th day of November 2016, killed only 4 persons. Count 2, felony murder. As to count 2, we find the defendant guilty. This 14th day of November 2014, killed only 4 persons. Count 3, felony murder. As to count 3, found the defendant guilty. This 14th day of November 2016, CN, 4 person. Count 4, cruelty to children in the first degree. As to count 4, we found the defendant guilty. This 14th day of November 2016, CN, 4 person. Count 5, cruelty to children in the second degree. As to count 5, we found the defendant guilty. This 14th day of November 2016, CN, 4 person. Count 6, criminal intent to commit a felony, to wit, sexual exploitation of children. As to count 6, we found the defendant guilty. This 14th day of November 2016, CN, 4 person. Count 7, dissemination of harmful materials to minors. As to count 7, we found the defendant guilty. This 14th day of November 2016, CN, 4 person. Count 8, dissemination of harmful materials to minors. As to count 8, we found the defendant guilty. This 14th day of November 2016, CN, 4 person.
Counsel approach to review the verdict. Does the state have further of the jury?
No, Your Honor.
Does the defense?
We'll ask for a poll.
Certainly. Ladies and gentlemen, we've received your verdict and it's been published in open court. The next step in a trial is the poll of the jury. The poll of the jury is when you're called upon to confirm that the verdict that has been rendered by the jury is in fact your verdict. The way I'll do that is the clerk will call your names by initials shortly. When your initials are called, please stand and I will ask you 3 questions. I'll ask you if you heard the verdict as it was read in open court, and then you would answer whatever your answer may be. The next thing I would ask is if the then I will ask you if the verdict that you heard is in fact the verdict that you had in your jury room. And then I'll ask you if in fact the verdict that you heard is the verdict of all the jurors in the jury room. And finally, I will ask you if the verdict is still your verdict. And then, as you know, you're under oath. To all of those 4 questions, you would answer truthfully as the case might be as to what your answer would be. And with that, I'll ask Mr. Phillips to go and begin to call the roll of the jurors.
J.G.
Please stand. Did you hear the verdict as it was read in open court?
Yes, I have.
Was that your verdict in the jury room?
Yes, it was.
Was it the verdict of your fellow jurors?
Yes, ma'am.
And is it still your verdict?
Yes, it is.
Thank you. Please be seated.
C.P.
Did you hear the verdict as it was read in open court?
Yes, ma'am.
Was wrong one? Eventually we'll be there. Yes, sir. Did you hear the verdict as it was read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it the verdict of your fellow jurors?
Yes, ma'am.
Is it still your verdict? Thank you. Be seated.
C.P.
Did you hear the verdict as it was read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it the verdict of your fellow jurors?
Yes, it was.
Is it still your verdict?
Yes, ma'am.
Please be seated.
S.M.
Did you hear the verdict as it was read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes.
Was it the verdict of your fellow jurors?
Yes.
Is it still your verdict?
Yes.
Thank you.
N.H.
Did you hear the verdict as it was read in open court?
Yes, Your Honor.
Was that your verdict in the jury room?
Yes, it was.
Is it still your verdict?
Yes, ma'am.
And was it the verdict of your fellow jurors?
Yes, Your Honor.
Thank you so much.
P.E.
Did you hear the verdict as it was read in open court?
Yes.
Was that the verdict? Was that your verdict in the jury room?
Yes.
Was it the verdict of your fellow jurors?
Yes.
Is it still your verdict?
Yes.
Thank you. Be seated.
P.O.
Did you hear the verdict as read in open court? Was that your verdict in the jury room? Was it the verdict of your fellow jurors? And is it still your verdict?
Yes.
Thank you.
J.J.
Did you hear the verdict as it was?
Two J.J. This is the male.
Did you hear the verdict as it was read in open court? Was that your verdict in the jury room?
Yes.
Was it the verdict of your fellow jurors? Is it still your verdict?
J.R.
Did you hear the verdict as it was read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it the verdict of your fellow jurors?
Yes, ma'am.
Is it still your verdict?
It is.
Thank you.
G.G.
Did you hear the verdict as read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it the verdict of your fellow jurors?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
J.J.
Did you hear the verdict as read in open court?
Yes, I did.
Was it your verdict in the jury room?
Yes, it was.
Was it the verdict of your fellow jurors?
Yes, it was.
Is it still your verdict?
Yes, it is.
K.N.
Did you hear the verdict as read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it the verdict of your fellow jurors?
Yes.
Is it still your verdict?
Yes.
Is that all of the jury? Anything further from the state?
No, Your Honor.
Anything further from the defense?
Not as far as the jury's concerned, Judge.
We'll take up issues in a moment. I'm going to give the verdict to the clerk. Ladies and gentlemen, that concludes your service on this case. So, what are next steps? Well, I'll be discharging you shortly, but I'd like you to know about the next steps in the case. As you remember that I told you in the charge of the court, I explained to you that sentencing was not an issue in your jury deliberations. And that's because we have a bifurcated system of jury trials, and bi means two, as you know. So the first step is the determination of guilt or innocence. You can't even begin to contemplate or consider or evaluate appropriate punishment until you've determined if a person is guilty or not guilty. And that is a jury function. That's where people from the community are brought together to bring about their really common sense. The verdict of a jury is the common group sense of the 12 jurors who come from all different walks of life, evaluating evidence, applying law to evidence, and letting that create a verdict. But you can't talk about punishment until a person has been found guilty. It doesn't make sense. In cases such as this, once a jury arrives at a verdict, and in this case a guilty verdict, then the responsibility of sentencing falls to the trial judge, and that's me. And what happens is called a sentencing hearing. And at a sentencing hearing, there can be evidence offered. And evidence would come to the court in one of two ways, basically two natures. One is in the nature of aggravation, and the other is in the nature of mitigation. Aggravating evidence is evidence that would take you to, say you had a median sentence, that all things being equal, this would be the normal sentence in a case. Aggravating evidence would be that which takes you to a stronger social response. Punishment is a social response to behavior that's against the law. And if there's evidence that's offered, and it can be evidence from the trial, maybe nothing more than, and often is, that there's no more evidence other than what's been heard at the trial. So that could be aggravating evidence. But it could also be something like prior criminal convictions, other things of that nature that the law allows the sentencing judge to take into account in arriving at the appropriate punishment. The other type of evidence is mitigating evidence, and that which, if we're at the meeting point, takes you to a less harsh sentence. Youth is often considered to be mitigating. There can be evidence in the trial that amounts to mitigating evidence. Lack of a criminal record can be mitigating evidence. There's a hearing to accomplish that, and each side, the state, can offer evidence in aggravation. The defense can offer evidence in mitigation, and then, just as you saw in the trial, there's argument. Each side can state what they think is an appropriate sentence within the range that the law sets out and argue to the court persuasively what's the appropriate sentence. I mentioned a feature that's important to keep in mind. I don't have unfettered decision-making, just like you didn't. You had law you had to follow based on evidence to arrive at a verdict. I have law I have to follow based on evidence in sentencing to arrive at a sentence. So what is the law specifically that I'm talking about? Each offense has sentences that are set forth by statute. The law that I told you about when I defined malice murder, when I defined felony murder, when I defined the cruelties to children and the dissemination counts, they all have ranges or specific punishments that go with that offense. And then there's some other nuanced aspects of how sentencing occurs. But after I discharge you, then I'll have to determine when the sentencing will occur. And I'll certainly want to share that information with you. You're a part of the case. I'm discharging you, and you're going to go back into your free lives, which you have not had for quite some time. And, for the rest of us, too, we haven't had our free lives either. We've been here in a very accommodating community. What's been here for us from Cobb County trying this case has been hospitality. hospitality has been remarkable. The support and help to us to do our task has been remarkable, and I hope for you that you find that to be true as well. I believe you probably do. It's just been very remarkable, and everyone involved should be commended. But you go back into your civic life and your civilian life, and yet I'm sure you would like to have the information so you can have access to being able to see and hear what happens in the sentencing. And I will be sure to get that to you so you will know. Why am I saying that? I don't know yet when we're going to do it. I need to listen to both sides. That's the next step after I discharge you, is to listen to the lawyers and talk about next steps as to when we get to sentencing. What type of preparation do they need? What is their time frame? Sometimes you try cases and you immediately have a sentencing. Oftentimes you have to wait because there are witnesses that need to be summoned and brought into court. So there's still moving parts on my end, their end as well. Before I discharge you, I'd like to say to you that you've seen, in my opinion, very good trial work. The lawyers have done an outstanding job in representing Mr. Harris and making sure that not only were his rights protected, and you know, sometimes we get a little jaded about rights, but rights matter because they define us as a society. And if, heaven forbid, we ever find ourselves in a circumstance or our family in a circumstance, we want to make sure we live in a society where those rights protected to us are there for us. It's an equalizer. It makes us all equal under the law. And that's one of the hallmarks of American society. And you have seen very good lawyering in that regard. You've also seen very good development of the facts and circumstances. The presentation was very good, and I see lawyers all the time. I am one. I'm pleased to be one. I'm very proud of the career choices I've made that have given me such an ability to see how our system works, how justice works in our country and in Georgia. And you've seen very high quality work, and I commend the lawyers for that. Having said that, I'm going to excuse you. I'm going to send you back to your jury room. The poor alternates, bless your hearts. You must have, I can't, every time I have to tell somebody they're an alternate, I go, you know, this is as punishing to me as it is to them to say, yep, we made you sit here. Yep, we made you listen, and now we're going to put you in a room, and you're going to have to play whatever, you know, do whatever y'all were doing. And the frustration, you know, I'm very sensitive to it. We couldn't have tried the case without you. What if somebody gotten sick? You would not believe, I was washing my hands every minute thinking, I do not need the flu. I got my shot, I don't need to get sick. And I was thinking, and you all don't need to be sick. Nobody needs to get sick. But what if somebody had? You know, it can happen. So we had to have the alternates for that purpose. Y'all have been a true pleasure to work with. You showed up on time, you've worked really hard, you've been attentive, all the things that I would say A++ jurors do, you all did. And I absolutely appreciate that very much. It's made it so much easier on all of us. Judges can't comment on verdicts, so if you think I'm going to, I'm not. Your function. You all have acquitted yourselves and worked hard and are greatly deserving of the hard work and attention, dedication that you've put to this.
Judge Mary Staley Clark excusing the jury in Brunswick. The 6 men and 6 women convicted Ross Harris of all 8 charges against him. Of course, the most serious being malice murder, Georgia's equivalent of first-degree murder. Ross Harris himself, not much reaction from him. No tears, closed his eyes a few times as he was absorbing the fact that he will probably spend the rest of his life in jail. Fox 5's Claire Sims has been in Brunswick throughout jury deliberations, and she's live outside the Glynn County Courthouse now with more. Claire?
Good afternoon, Russ. The first thing I want to do is let's go over all those counts, because For a lot of people at home, it's 8 separate counts. It's probably not exactly easy to keep up with. So the first count was malice murder. That was obviously the most serious, as you mentioned. The next 2 were felony murder, and that one was related to child cruelty in the first degree. The third count was felony murder with child cruelty in the second degree. Now, all 3 of those murder counts all come with a life sentence, which in Georgia is 30 years. But it's my understanding from talking to the Cobb County District Attorney's Office that likely those life sentences will all be sort of squeezed into one. The fourth count was cruelty to children in the first degree. That carries a sentence of 5 to 20 years, depending on what the judge thinks he should face for that count. Count number 5 is cruelty to children in the second degree. That one comes with a sentence of 1 to 10 years. Count number 6. This is where we start to get into what the prosecution called Ross Harris's double life. These are the counts that relate to his sexting of other women outside of his marriage. So count number 6 was criminal attempt to commit a felony, and in this case, that was specifically sexual exploitation of children. Count number 7 was dissemination of harmful material to a minor. So again, those pictures and messages that we heard from the prosecution that Mr. Harris was exchanging with young women, including women who were not of age. Count number 8, unlawful distribution of material to minors, again related to those sexting charges. Now, on those last 3, the criminal attempt to commit a felony, sexual exploitation of children, that carries a sentence of 1 to 10 years. And then counts 7 and 8, the dissemination of harmful material, those come with a maximum sentence of 12 months. Of course, at this point, Ross Harris has already served more than that, just waiting for trial. Again, the jury found him guilty on all 8 counts, and according to the Cobb County District Attorney's Office, according to their math, they believe the maximum sentence that Ross Harris could face at this point would be life plus 42 years. Now, of course, this is a trial that's been going on really for a couple of months now. We had jury selection start in early September. Then we had actual testimony begin the first week of October. And then it was last week that the jury got their chance to start looking at all of these counts, reviewing the evidence, and deciding what they thought about all 8. And again, their verdict this afternoon is that Ross Harris is guilty of all 8 counts that the prosecution brought. Now let's go back inside to listen to court.
The state will be ready whenever, Your Honor. We do have to, I think, under the law, notify next of kin and victim and the latter counts of the indictment for when sentencing is going to be set. But we'll try to do that as soon as we can. As soon as Your Honor sets a date, we're ready whenever.
Defense?
We're ready now.
Well, they have to notify people. I don't see that as happening.
What are we doing first week of December?
Have you got the calendar?
Okay, so that calendar call.
How long do you anticipate the sentencing hearing to be?
From the state's position, probably no more than 15, 20 minutes.
And from the defense, do you have an estimation?
We will be putting up no evidence nor making any argument.
Let's set it for December the 5th at 1:30 in my courtroom in Cobb County. All right, we need to advise the defendant of his appellate rights. Mr. Kilgore, I don't anticipate you've had an opportunity to discuss that with your client.
They've been discussed at great length.
And to your credit, do you want to make a predicate statement of some sort?
I do not.
Well, okay, then what have you advised him of?
That if he's convicted, he has the right to appeal, and we'll be taking care of that.
You're going to take care of that?
Yes, ma'am.
Okay, all right. Well, then, Mr. Harris, your counsel has advised me that y'all have discussed appellate issues at length, and that they are going to file the notices of appeal in a timely manner. Generally, that's going to be within 30 days, at least kind of a blanket notice of appeal to be fleshed out at a later time. Would that be consistent with what you advised me, Mr. Kilgore?
We went into a good bit more detail, but he's aware of those rights that he has, and he's aware that we're going to be handling those in the proper fashion, Judge.
Well, the thing that's important for me to tell Mr. Harris is that he's got 30 days to file a notice of appeal, and it can be very blanket and pro forma, but the 30 days is the deadline, and that's what needs to be said by the court. Mr. Harris, do you understand that?
Yes, ma'am.
Thank you. All right, is there anything else for the state?
No, Your Honor.
Is there anything else for the defense?
Not at this time, Judge.
Do you want to step back and see the jury?
We would, Judge. I know we'd spoken about this earlier. It may not be the best idea, but just a thought we had, possibly so they don't feel pressure if they wanted to come back maybe in the morning to the courthouse for a meeting in a room or something like that, to meet at maybe 8:30, 9 o'clock if they're open to that way. Just a thought.
I'm inclined to say, they'll say no thank you.
But we would like a minute to speak with them if at all possible.
Well, y'all just stay put and I'll work it out to where it's going to be best for everybody.
Yes, ma'am.
How about the defense?
I think that at least one of us is probably going to want to speak to him.
Perfect. All right. Sheriff Jump, thank you so much for your officers and your outstanding hospitality.
Judge Becker,
Greatly appreciated. All right, I'm going to take a recess now, and I'm going to get the jury settled and figure out what's the best place. They may want to come in here, but I don't know that they're going to want to. Ladies and gentlemen, the press may not be who they're interested in. I don't know. You know, at this point, they're free agents. Let's let them have some freedom and some input into what we do. So I will go and work on that. This court stands in recess.
Judge Mary Staley Clark puts the court in recess. She will announce the sentence on December 5th at 1:30 p.m. back in Cobb County. As you can see there, Ross Harris leaving the Glynn County Courthouse. Worth remembering that there were weeks of jury selection in Cobb County before Judge Staley announced that he could not get a fair trial in Cobb County because of all the pretrial publicity. Cooper Harris died on June 18th, 2014, just 22 months old. It has been 30 months since his death. And now Ross Harris is convicted of all the charges against him: malice murder, 2 counts of felony murder, 2 counts of cruelty to children in the 1st and 2nd degree, sexual exploitation of children, and 2 counts of disseminating harmful material to minors. What we just heard the judge saying is that she's going to arrange an opportunity for both the defense and the prosecution to talk to the jury to find out what moved them in this trial, what motivated them. And we are going to try to do the same. Our Claire Sims is on the scene, so is Angelique Proctor. We're going to try to talk to the jury. Of course, they're free not to talk to us, but we'll ask them what it was that convinced them of Ross Harris's guilt. Let's toss back to Claire.
Yeah, Russ, well, one of the things that we've been seeing throughout the jury deliberation, let me give you a little bit of the timeline. The jury was actually given this case and began deliberating last Tuesday, November 8th, the same day as Election Day. They only worked a half day that day so that they could go and vote in the presidential election. Then they came back and worked a full day Wednesday, a full day on Thursday, and then were off court for Friday for Veterans Day. They came back this morning, and we heard from people throughout the courthouse. Last week, we reported that we saw a juror who was actually crying and had fellow jurors sort of comforting her during a break here at the courthouse. Today, court administrators told us that things seemed a little more subdued. They heard last week maybe a little more arguing in the jury room. Today, it was more subdued, more calm. And again, now I guess we believe that that was because they were closer to making a determination and, of course, agreeing at this point on all 8 counts and finding Ross Harris guilty. So we had a half day of deliberation last Tuesday, 2 full days, Wednesday and Thursday, and then a little bit more than a half day of deliberation today before the jury was able to reach a consensus on all 8 counts. And one of the things that we saw last week is the jurors did ask to review some of the evidence, and they had most of the evidence in their jury room, but when it came to electronic evidence in this case, they had to review that in the courtroom under supervision. So we saw them rewatch the interview of Ross Harris the first day after this happened. Him being interviewed by Cobb County Police Detective Phil Stoddard. We saw him sitting in the room alone. And one of the big questions that the prosecution put in the jurors' minds was were his emotions sincere on the day that his son died? And it seemed apparent to us that the jurors were re-watching that video to watch Mr. Harris in that interrogation room by himself, or in that interview room, to see if they could gauge his emotions. So they not only watched the interview with Detective Stoddard again, they also went back and watched when Leanna Harris, now Leanna Taylor, Harris's former wife, visited him just hours after Cooper's death. And were their interactions sincere? They also went back and watched the video of Harris dropping off light bulbs at his car. Now, you may remember during this story, Harris went to lunch with some coworkers, stopped by Home Depot to pick up some light bulbs, and then at lunch was spotted on surveillance camera. The prosecution said he just sort of tossed those light bulbs into the car because he didn't want to look into the car because he knew what was in there. The jury rewatched that video so that they could determine if the prosecution's theory on that was correct. And at this point, with all of these guilty verdicts, it sounds as though the jury did agree with the prosecution's version of this case. Russ?
Claire, very well said. And that means that Ross Harris intended to do this, planned to do this from the very beginning. That's what malice murder means, as you know, first-degree murder. They could have convicted him of felony murder with criminal negligence. He still would have spent life in prison. But this jury eventually came to the conclusion, did it not, that this was a plan from the very beginning, something he thought out, and that he left his child to die there intentionally.
Yeah, and that was the prosecution's story sort of the whole time. They claimed that Harris was living a double life, that he was married with a young son, but he was also meeting women online or on social media apps, meeting up with them for sex and for other rendezvous, and really sort of leading this double life. Now, the prosecution claimed that by getting rid of his son, Cooper, that he was potentially able to escape his responsibilities as a husband and a father. But of course, the defense said he loved that little boy. The defense brought evidence that he was planning a vacation with the family and that the family was looking for a larger home. But the prosecution was able to, in their closing, sort of knock down some of those theories that the defense presented to the jury.
Well, the defense attorney, Maddox Kilgore, told the jury, eccentricities and moral failures do not change the fact that this was an accident. And accidents like this do happen all over the country, 36 times a year on average. But clearly this jury did not believe that in this particular case, and the defense tried to say, look, this is about demeanor. Had Ross Harris not acted strangely on the day of his son's death, none of this would have happened in court. But clearly the jury sided with the prosecution and vindicated their decision to bring what were very unusual murder charges under the circumstances.
Yeah, exactly. And I remember, that we watched that video again with Leanna Harris in the interview room with her husband saying, what did you say? Why have they charged you? What are you being charged with? Really not understanding exactly what the extent of this would be. But that was a big question. I remember when this first happened, that people were saying they weren't sure if this was criminal. Obviously, the jury here in England County, Georgia today believes that it was.
Claire Sims, live, England County. Thank you so much. So this is justice for Cooper Harris. The sentencing, again, will happen on December 5th, back in Cobb County, 1:30 in the afternoon, in Judge Mary Staley Clark's courtroom. It will be life in prison. The question is life plus how much? And we heard Maddox Kilgore, the defense attorney for Ross Harris, say that they will appeal. They have 30 days to file that appeal, so perhaps this is not over, but at least for today, justice has been served. We heard the judge say that this was good lawyering on both sides, that the lawyers for the prosecution and the defense did their jobs. It is guilty on all counts, including the most serious, malice murder, Georgia's equivalent of first-degree murder, the death penalty off the table. We're going to try to talk to the jury and have complete coverage for you one way or the other coming up on Fox 5 News at 5 and 6. Thanks for being with us this afternoon.